Republic Act No. 386, Civil Code of the Philippines. Book 3, Different Modes of Acquiring Ownership. Preliminary Provision. Article 712. Ownership is acquired by occupation and by intellectual creation. Ownership and other real rights over property are acquired and transmitted by law, by donation, by testate and intestate succession, and in consequence of certain contracts, by tradition. They may also be acquired by means of prescription. Title 1. Occupation. Article 713. Things appropriable by nature which are without an owner, such as animals that are the object of hunting and fishing, hidden treasure, and abandoned movables, are acquired by occupation. Article 714. The ownership of a piece of land cannot be acquired by occupation. Article 715. The right to hunt and to fish is regulated by special laws. Article 716. The owner of a swarm of bees shall have a right to pursue them to another's land, indemnifying the possessor of the latter for the damage. If the owner has not pursued the swarm or ceases to do so within 2 consecutive days, the possessor of the land may occupy or retain the same. The owner of domesticated animals may also claim them within 20 days to be counted from their occupation by another person. This period having expired, they shall pertain to him who has caught and kept them. Article 717. Pigeons and fish, which from their respective breeding places pass to another pertaining to different owner, shall belong to the latter, provided they have not been enticed by some article or fraud. Article 718. He who by chance discovers hidden treasure in another's property shall have the right granted him in Article 438 of this Code. Article 719. Whoever finds a movable, which is not treasure, must return it to its previous possessor. If the latter is unknown, the finder shall immediately deposit it with the mayor of the city or municipality where the finding has taken place. The finding shall be publicly announced by the mayor for 2 consecutive weeks in the way he deems best. If the movable cannot be kept without deterioration or without expenses which considerably diminish its value, it shall be sold at public auction 8 days after the publication. 6 months from the publication having elapsed without the owner having appeared, the thing found or its value shall be awarded to the finder. The finder and the owner shall be obliged, as the case may be, to reimburse the expenses. Article 720. If the owner should appear in time, he shall be obliged to pay, as a reward to the finder, 1/10 of the sum or of the price of the thing found. Title 2. Intellectual Creation. Article 721. By intellectual creation, the following persons acquire ownership. 1. The author with regard to his literary, dramatic, historical, legal, philosophical, scientific, or other work. 2. The composer as to his musical composition. 3. The painter, sculptor, or other artist with respect to the product of his art. 4. The scientist or technologist or any other person with regard to his discovery or invention. Article 722. The author and the composer mentioned in numbers 1 and 2 of the preceding article shall have the ownership of their creations even before the publication of the same. Once their works are published, their rights are governed by the copyright laws. The painter, sculptor, or other artist shall have dominion over the product of his art even before it is copyrighted. The scientist or technologist has the ownership of his discovery or invention even before it is patented. Article 723. Letters and other private communications in writing are owned by the person to whom they are addressed and delivered, but they cannot be published or disseminated without the consent of the writer or his heirs. However, the court may authorize their publication or dissemination if the public good or the interest of justice so requires. Article 724. Special laws govern copyright and patent. Title 3. Donation. Chapter 1. Nature of donations. Article 725. Donation is an act of liberality whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. Article 726. When a person gives to another a thing or right on account of the latter's merits or of the services rendered by him to the donor, provided they do not constitute a demandable debt, or when the gift imposes upon the donee a burden which is less than the value of the thing given, there is also a donation. Article 727. Illegal or impossible conditions in simple and remuneratory donations shall be considered as not imposed. Article 728. Donations which are to take effect upon the death of the donor partake of the nature of testamentary provisions and shall be governed by the rules established in the title on succession. Article 729. When the donor intends that the donation shall take effect during the lifetime of the donor, though the property shall not be delivered till after the donor's death, this shall be a donation inter vivos. The fruits of the property from the time of the acceptance of the donation shall pertain to the donee unless the donor provides otherwise. Article 730. The fixing of an event or the imposition of a suspensive condition which may take place beyond the natural expectation of life of the donor does not destroy the nature of the act as a donation inter vivos unless a contrary intention appears. Article 731. When a person donates something, subject to the resolutory condition of the donor's survival, there is a donation inter vivos. Article 732. Donations which are to take effect inter vivos shall be governed by the general provisions on contracts and obligations in all that is not determined in this title. Article 733. Donations with an onerous cause shall be governed by the rules on contracts and remuneratory donations by the provisions of the present title as regards that portion which exceeds the value of the burden imposed. Article 734. The donation is perfected from the moment the donor knows of the acceptance by the donee. Chapter 2. Persons who may give or receive a donation. Article 735. All persons who may contract and dispose of their property may make a donation. Article 736. Guardians and trustees cannot donate the property entrusted to them. Article 737. The donor's capacity shall be determined as of the time of the making of the donation. 738. All those who are not specially disqualified by law therefore may accept donations. Article 739. The following donations shall be void. 1. Those made between persons who were guilty of adultery or concubinage at the time of the donation. 2. Those made between persons found guilty of the same criminal offense in consideration thereof. 3. Those made to a public officer or his wife, descendants, and ascendants by reason of his office. In the case referred to in number 1, the action for declaration of nullity may be brought by the spouse of the donor or donee, and the guilt of the donor and donee may be proved by preponderance of evidence in the same action. Article 740. Incapacity to succeed by will shall be applicable to donations inter vivos. Article 741. Minors and others who cannot enter into a contract may become donees, but acceptance shall be done through their parents or legal representatives. Article 742. Donations made to conceived and unborn children may be accepted by those persons who would legally represent them if they were already born. Article 743. Donations made to incapacitated persons shall be void, though simulated under the guise of another contract or through a person who is interposed. Article 744. Donations of the same thing to two or more different donees shall be governed by the provisions concerning the sale of the same thing to two or more different persons. Article 745. The donee must accept the donation personally or through an authorized person with a special power for the purpose, with a general and sufficient power. Otherwise, the donation shall be void. Article 746. Acceptance must be made during the lifetime of the donor and of the donee. Article 747. Persons who accept donations in representation of others who may not do so by themselves shall be obliged to make the notification and notation of which Article 749 speaks. Article 748. The donation of a movable may be made orally or in writing. An oral donation requires the simultaneous delivery of the thing or of the document representing the right donated. If the value of the personal property donated exceeds 5,000 pesos, the donation and the acceptance shall be made in writing. Otherwise, the donation shall be void. Article 749. In order that the donation of an immovable may be valid, it must be made in a public document, specifying therein the property donated and the value of the charges which the donee must satisfy. The acceptance may be made in the same deed of donation or in a separate public document, but it shall not take effect unless it is done during the lifetime of the donor. If the acceptance is made in a separate instrument, the donor shall be notified thereof in an authentic form, and this step shall be noted in both instructions. Chapter 3. Effect of donations and limitations thereon. Article 750. The donation may comprehend all the present property of the donor or part thereof, provided he reserves, in full ownership or in usufruct, sufficient means for the support of himself and of all relatives who, at the time of the acceptance of the donation, are by law entitled to be supported by the donor. Without such reservation, the donation shall be reduced in petition of any person affected. Article 751. Donations cannot comprehend future property. By future property is understood anything which the donor cannot dispose of at the time of the donation. Article 752. The provisions of Article 750 notwithstanding, no person may give or receive by way of donation more than he may give or receive by will. The donation shall be inefficacious in all that it may exceed this limitation. Article 753. When a donation is made to several persons jointly, it is understood to be in equal shares, and there shall be no right of accretion among them unless the donor has otherwise provided. The preceding paragraph shall not be applicable to donations made to the husband and wife jointly, between whom there shall be a right of accretion, if the contrary has not been provided by the donor. Article 754. The donee is abrogated to all the rights and actions which, in case of eviction, would pertain to the donor. The latter, on the other hand, is not obliged to warrant the things donated, save when the donation is onerous, in which case the donor shall be liable for eviction to the concurrence of the burden. The donor shall also be liable for eviction or hidden defects in case of bad faith on his part. Article 755. The right to dispose of some of the things donated, or of some amount which shall be a charge thereon, may be reserved by the donor. But if he should die without having made use of this right, the property or amount reserved shall belong to the donee. Article 756. The ownership of property may also be donated to one person and the use of rack to another or others, provided all the donees are living at the time of the donation. Article 757. Reversion may be validly established in favor of only the donor for any case and circumstances, but not in favor of other persons unless they are all living at the time of the donation. Any reversion stipulated by the donor in favor of a third person in violation of what is provided in the preceding paragraph shall be void, but shall not nullify the donation. Article 758. When the donation imposes upon the donee the obligation to pay the debts of the donor, if the clause does not contain any declaration to the contrary, the former is understood to be liable to pay only the debts which appear to have been previously contracted. In no case shall the donee be responsible for the debts exceeding the value of the property donated, unless a contrary intention clearly appears. Article 759. There being no stipulation regarding the payment of debts, the donee shall be responsible therefore only when the donation has been made in fraud of creditors. The donation is always presumed to be in fraud of creditors when at the time thereof the donor did not reserve sufficient property to pay his debts prior to the donation. Chapter 4. Revocation and Reduction of Donations. Article 760. Every donation inter vivos made by a person having no children or descendants, legitimate or legitimated by subsequent marriage, or illegitimate, may be revoked or reduced as provided in the next article by the happening of any of these events. 1. If the donor, after the donation, should have legitimate or legitimated or illegitimate children, even though they be posthumous. 2. If the child of the donor, whom the latter believed to be dead when he made the donation, should turn out to be living. 3. If the donor should subsequently adopt a minor child. Article 761. In the cases referred to in the preceding article, the donation shall be revoked or reduced insofar as it exceeds the portion that may be freely disposed of by will, taking into account the whole estate of the donor at the time of the birth, appearance, or adoption of a child. Article 762. Upon the revocation or reduction of the donation by the birth, appearance, or adoption of a child, the property affected shall be returned or its value if the donee has sold the same. If the property is mortgaged, the donor may redeem the mortgage by paying the amount guaranteed with a right to recover the same from the donee. When the property cannot be returned, it shall be estimated at what it was worth at the time of the donation. Article 763. The action for revocation or reduction on the grounds set forth in Article 760 shall prescribe after 4 years from the birth of the first child, or from his legitimation, recognition, or adoption, or from the judicial declaration of filiation, or from the time information was received regarding the existence of the child believed dead. This action cannot be renounced and is transmitted upon the death of the donor to his legitimate and illegitimate children and descendants. Article 764. The donation shall be revoked at the instance of the donor when the donee fails to comply with any of the conditions which the former imposed upon the latter. In this case, the property donated shall be returned to the donor, the alienations made by the donee, and the mortgages imposed thereon by him being void, with the limitations established with regard to third persons by the mortgage law and the land registration laws. This action shall prescribe after 4 years from the non-compliance with the condition, may be transmitted to the heirs of the donor, and may be exercised against the donee's heirs. Article 765. The donation may also be revoked at the instance of the donor by reason of ingratitude in the following cases. 1. If the donee should commit some offense against the person, the honor, or the property of the donor, or of his wife or children under his parental authority. 2. If the donee imputes to the donor any criminal offense or any act involving moral turpitude, even though he should prove it, unless the crime or the act has been committed against the donee himself, his wife, or children under his authority. 3. If he unduly refuses him support when the donee is legally or morally bound to give support to the donor. Article 766. Although the donation is revoked on account of ingratitude, nevertheless, the alienations and mortgages effected before the notation of the complaint for revocation in the registry of property shall subsist. Later ones shall be void. Article 767. In the case referred to in the first paragraph of the preceding article, the donor shall have a right to demand from the donee the value of property alienated which he cannot recover from third persons, or the sum for which the same has been mortgaged. The value of said property shall be fixed as of the time of the donation. Article 768. When the donation is revoked for any of the causes stated in Article 760, or by reason of ingratitude, or when it is reduced because it is inefficacious, the donee shall not return the fruits except from the filing of the complaint. If the revocation is based upon non-compliance with any of the conditions imposed in the donation, the donee shall return not only the property, but also the fruits thereof which he may have received after having failed to fulfill the condition. Article 769. The action granted to the donor by reason of ingratitude cannot be renounced in advance. This action prescribes within 1 year to be counted from the time the donor had knowledge of the fact and it was possible for him to bring the action. Article 770. This action shall not be transmitted to the heirs of the donor if the latter did not institute the same, although he could have done so, and even if he should die before the expiration of 1 year. Neither can this action be brought against the heir of the donee unless upon the latter's death the complaint has been filed. Article 771. Donations which, in accordance with the provisions of Article 752, are inofficious, bearing in mind the estimated net value of the donor's property at the time of his death, shall be reduced with regard to the excess. But this reduction shall not prevent the donations from taking effect during the life of the donor, nor shall it bar the donee from appropriating the fruits. For the reduction of donations, the provisions of this chapter and of Articles 911 and 912 of this code shall govern. Article 772. Only those who at the time of the donor's death have a right to the legitime, and their heirs and successors in interest, may ask for the reduction or inofficious donations. Those referred to in the preceding paragraph cannot renounce their right during the lifetime of the donor, either by express declaration or by consenting to the donation. The donees, devisees, and legatees who are not entitled to the legitime and the creditors of the deceased can neither ask for the reduction nor avail themselves thereof. Article 773. If, there being 2 or more donations, the disposable portion is not sufficient to cover all of them, those of the more recent date shall be suppressed or reduced with regard to the excess. Note: the audio codal for Title 4, Succession, shall be available in a different video, the link of which shall be available in the description box below. End of note. Title 5, Prescription. Chapter 1, General Provisions. Article 1106. By prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by law. In the same way, rights and actions are lost by prescription. Article 1107. Persons who are capable of acquiring property or rights by the other legal modes may acquire the same by means of prescription. Minors and other incapacitated persons may acquire property or rights by prescription, either personally or through their parents, guardians, or legal representatives. Article 1108. Prescription, both acquisitive and extinctive, runs against 1. Minors and other incapacitated persons who have parents, guardians, or other legal representatives. 2. Absentees who have administrators, either appointed by them before their disappearance or appointed by the courts. 3. Persons living abroad who have managers or administrators. 4. Juridical persons except the state and its subdivisions. Persons who are disqualified from administering their property have a right to claim damages from their legal representatives whose negligence has been the cause for prescription. Article 1109. Prescription does not run between husband and wife even though there be a separation of property agreed upon in the marriage settlements or by judicial decree. Neither does prescription run between parents and children during the minority or insanity of the latter, and between guardian and ward during the continuance of the guardianship. Article 1110. Prescription, acquisitive and extinctive, runs in favor of or against a married woman. Article 1111. Prescription obtained by a co-proprietor or a co-owner shall benefit the others. Article 1112. Persons with capacity to alienate property may renounce prescription already obtained but not the right to prescribe in the future. Prescription is deemed to have been tacitly renounced when the renunciation results from acts which imply the abandonment of the right acquired. Article 1113. All things which are within the commerce of men are susceptible of prescription unless otherwise provided. Property of the state or any of its subdivisions not patrimonial in character shall not be the object of prescription. Article 1114. Creditors and all other persons interested in making the prescription effective may avail themselves thereof, notwithstanding the express or tacit renunciation by the debtor or proprietor. Article 1115. The provisions of the present title are understood to be without prejudice to what in this code or in special laws is established with respect to specific cases of prescription. Article 1116. Prescription already running before the effectivity of this code shall be governed by laws previously in force. But if since the time this code took effect, the entire period herein required for prescription should elapse, the present code shall be applicable, even though by the former laws a longer period might be required. Chapter 2. Prescription of ownership and other real rights. Article 1117. Acquisitive prescription of dominion and other real rights may be ordinary or extraordinary. Ordinary acquisitive prescription requires possession of things in good faith and with just title for the time fixed by law. Article 1118. Prescription has to be in the concept of an owner, public, peaceful, and uninterrupted. Article 1119. Acts of possessory character executed in virtue of license or by mere tolerance of the owner shall not be available for the purposes of possession. Article 1120. Possession is interrupted for the purposes of prescription, naturally or civilly. Article 1121. Possession is naturally interrupted when through any cause it should cease for more than 1 year. The old possession is not revived if a new possession should be exercised by the same adverse claimant. Article 1122. If the natural interruption is for only 1 year or less, the time elapsed shall be counted in favor of the prescription. Article 1123. Civil interruption is produced by judicial summons to the possessor. Article 1124. Judicial summons shall be deemed not to have been issued and shall not give rise to interruption. 1. If it should be void for lack of legal solemnities. 2. If the plaintiff should desist from the complaint or should allow the proceedings to lapse. 3. If the possessor should be absolved from the complaint. In all these cases, the period of the interruption shall be counted for the prescription. Article 1125. Any express or tacit recognition which the possessor may make of the owner's right also interrupts possession. Article 1126. Against a title recorded in the Registry of Property, ordinary prescription of ownership or real rights shall not take place to the prejudice of a third person, except in virtue of another title also recorded, and the time shall begin to run from the recording of the latter. As to lands registered under the Land Registration Act, the provisions of that special law shall govern. Article 1127. The good faith of the possessor consists in the reasonable belief that the person from whom he received the thing was the owner thereof and could transmit his ownership. Article 1128. The conditions of good faith required for possession in Articles 526, 527, 528, and 529 of this Code are likewise necessary for the determination of good faith in the prescription of ownership and other real rights. Article 1129. For the purposes of prescription, there is just title when the adverse claimant came into possession of the property through one of the modes recognized by law for the acquisition of ownership or other real rights, but the grantor was not the owner or could not transmit any right. Article 1130. The title for prescription must be true and valid. Article 1131. For the purposes of prescription, just title must be proved. It is never presumed. Article 1132. The ownership of movables prescribes through uninterrupted possession for 4 years in good faith. The ownership of personal property also prescribes through uninterrupted possession for 8 years without need of any other condition. With regard to the right of the owner to recover personal property lost or of which he has been illegally deprived, as well as with respect to movables acquired in a public sale, fair, or market, or from a merchant store, the provisions of Article 559 and 1505 of this Code shall be observed. Article 1133. Movables possessed through a crime can never be acquired through prescription by the offender. Article 1134. Ownership and other real rights over immovable property are acquired by ordinary prescription through possession of 10 years. Article 1135. In case the adverse claimant possesses by mistake an area greater or less than that expressed in his title, prescription shall be based on the possession. Article 1136. Possession in wartime, when the civil courts are not open, shall not be counted in favor of the adverse claimant. Article 1137. Ownership and other real rights over immovables also prescribed through uninterrupted adverse possession thereof for 30 years without need of title or of good faith. Article 1138. In the computation of time necessary for prescription, the following rules shall be observed. 1. The present possessor may complete the period necessary for prescription by tacking his possession to that of his grantor or predecessor in interest. 2. It is presumed that the present possessor, who was also the possessor at a previous time, has continued to be in possession during the intervening time unless there is proof to the contrary. 3. The first day shall be excluded and the last day included. Chapter 3. Prescription of Actions. Article 1139. Actions prescribed by the mere lapse of time fixed by law. Article 1140. Actions to recover movables shall prescribe 8 years from the time the possession thereof is lost, unless the possessor has acquired the ownership by prescription for a less period, according to Articles 1132, and without prejudice to the provisions of Articles 559, 1505, and 1133. Article 1141. Real actions over immovables prescribed after 30 years. This provision is without prejudice to what is established for the acquisition of ownership and other real rights by prescription. Article 1142. A mortgage action prescribes after 10 years. Article 1143. The following rights, among others specified elsewhere in this Code, are not extinguished by prescription. 1. To demand a right of way, regulated in Article 649. 2. To bring an action to abate a public or private nuisance. Article 1144. The following actions may be brought within 10 years from the time the right of action accrues. 1. Upon a written contract. 2. Upon an obligation created by law. 3. Upon a judgment. Article 1145. The following actions must be commenced within 6 years. 1. Upon an oral contract. 2. Upon a quasi-contract. Article 1146. The following actions must be instituted within 4 years. 1. Upon an injury to the rights of the plaintiff. 2. Upon a quasi-delict. However, when the action arises from or out of any act, activity, or conduct of any public officer involving the exercise of powers or authority arising from martial law, including the arrest, detention, and/or trial of the plaintiff, the same must be brought within 1 year. Article 1147. The following actions must be filed within 1 year. 1. For forcible entry and detainer. 2. For defamation. Article 1148. The limitations of action mentioned in Articles 1140 to 1142 and 1144 to 1147 are without prejudice to those specified in other parts of this code, in the Code of Commerce, and in special laws. Article 1149. All other actions, whose periods are not fixed in this code or in other laws, must be brought within 5 years from the time the right of action accrues. Article 1150. The time for prescription for all kinds of actions, when there is no special provision which ordains otherwise, shall be counted from the day they may be brought. Article 1151. The time for the prescription of actions which have for their object the enforcement of obligations to pay principal with interest or annuity runs from the last payment of the annuity or of the interest. Article 1152. The period for prescription of actions to demand the fulfillment of obligation declared by a judgment commences from the time the judgment became final. Article 1153. The period for prescription of actions to demand accounting runs from the day the persons who should render the same cease in their functions. The period for the action arising from the result of the accounting runs from the date when said result was recognized by agreement of the interested parties. Article 1154. The period during which the obligee was prevented by a fortuitous event from enforcing his right is not reckoned against him. Article 1155. The prescription of actions is interrupted when they are filed before the court, when there is a written extrajudicial demand by the creditors, and when there is any written acknowledgement of the debt by the debtor.